the European issues related to children migration, what are the current policies, what are the children's rights that are at stake, and what are the messages that have been developed by other participants in this initiative, and that can be obviously, that are shared and can be obviously used by others that are concerned with the same issues and working on similar matters. We have tried to provide in the section called Spotlight of EU an analysis of the main policies that exist at European and national level, and try to link them with child rights at stake and with the current work on this matter and the opportunities that are coming up. And we also have a section that's called Priority Issues, where you can see all the collection of the policy briefs that have been developed within this initiative in the last couple of years, and also the recordings of the several webinars that have taken place in these last years. So this is a little bit what the Initiative for Children Migration is, and so the framework in which this webinar takes place. Why we are doing this, I think it's clear for everyone. In September, the Commission published the very long, something that we were waiting for the long time, the Pact on Migration and Asylum. This pact obviously has an impact on thousands of children that are in Europe or that will come to Europe. And there are a lot of legislative instruments that have are going to go through negotiations in the next months and years, that we want to make sure provide high standards for the reception of the children in Europe, for the procedures related to their status, and everything that has to deal with their situations when in Europe. So what we're going to try to do today is simply to give you a little bit more of information of what are the situations related to children in migration in the Pact, what is the process at the moment, so what is going to happen with the Pact, where we are going to go in the next months, and in the years probably. So what are the opportunities that are coming up? We also want to give you a little bit more information on the main concerns that we have spotted, and when I say we, I mean Missing Children Europe, Child Circle, Save the Children, and PICUM, with whom we have analyzed the Pact and tried to pull out the key issues that we think need to be prioritized at the moment, and that for us are red lines, and that we want you to know more. So we're doing this because we think that many have an interest in knowing more about not only the Pact but also the child rights issues at stake, and that many among you may want to know what are messages that others support and that we want to advocate for together. This is the core of the Initiative for Children Migration. Let's try to make our voices stronger because we support each other and we support each other's messages. And one thing that will follow this webinar is a joint position that Missing Children Europe, PICUM, Save the Children, and Child Circle are currently finalizing, and that we want to share largely for endorsements, and that in practice what this joint position does is that it summarizes the messages, the main concerns that we're going to discuss today. So if you share some of these concerns, you are very invited to support our joint position, sign it, and share it with us when we will publish it. So some already mentioned, Karen already mentioned that we have a little poll to break the ice today. So if Paola from Missing Children Europe is assisting today with the technicalities of the webinar, if you can show the poll. You can go to more. If you don't see the poll, you can go to more, the three dots that are at the bottom of your screen, and click polls, and a couple of questions should pop up. I hope you all see them. We would like to know who's in the audience today, who's with us. So first thing that we would like to know is the kind of organization you're working for. And also we would like to know what are you mostly interested in today. For the first question, of course, you have only one option, but you can definitely pick a few answers when it comes to the second question. So I'll give you a few seconds to reply. And of course, don't forget to click submit. So I'll give you 10 more seconds just to make sure that everyone managed to reply. Well, I think we can close the poll. Paula should be able to show us a little bit the picture of the audience today. I hope this is going to work.
Yes, I think you should be able. Do you see it or not? Like the, no, you don't see the percentage?
Not yet. Ah, now we can. So as expected, most of you are European NGOs, which makes sense because indeed this webinar, with this webinar, we first target the participants in the migration, in the Initiative for Children and Migration, but we also targeted some people that have attended webinars that we have organized in the past. But then we see a lot of national NGOs, UN agencies, and some national authorities, which is really interesting. And then I think I see that most of you are interested, obviously, in the child rights at stake, but also in general about the Pact, advocacy opportunities coming up. So before going to the first point in the agenda, which is indeed about the in general information about the Pact, I just wanted to give you some information on the coming up opportunities organized within the Initiative for Children and Migration. Paula, can you share the PowerPoint again? So we are organizing a couple of other meetings within the next couple of months. One is going to take place on the 7th of December, and it's about the need of a child-centered relocation of children in the EU, now and in the future. We're going to discuss current practices and what does it mean for a future more stable relocation mechanism for children. This is a follow-up of another webinar that took place in the summer about the ad hoc mechanism of the Commission to relocate children from Greece. And then we have another webinar that will take place in January, and it's about border procedures specifically. So we're going to discuss some of this today already, but that webinar will be specifically only on border procedures. I already mentioned the fact that there will be a joint position open for endorsement this week. So if you can, we can go to the agenda, Paula. As I said, this meeting is organized by Child Circle, Save the Children, PICUM, and Missing Children Europe. And the first point in the agenda is a general presentation on the Pact before going into the hot topics that we have identified. And so I will give the floor now to Karen Metz from Save the Children for an overview of the Pact issue.
Thanks. I think we need to move on a couple of slides. Yes, thank you so much. Hello, I'm Karen. I work for Karen Metz. I work for Save the Children Europe for the time being. I am going to just talk about very general what has been presented on December 23rd and already touch upon some of the key issues, and then I think Rebecca and Federica will go into more detail about it. So the new Pact on Migration and Asylum was announced on the 23rd of September. The way it was announced, you would think it is a done deal, but in fact, it is just the beginning of a process. So the Pact is a communication, which is basically a plan by the Commission outlining its key priorities and a whole number of legislative proposals. There were a number of new proposals which were the screening regulation, the asylum and migration management regulation, replacing Dublin. I mean, the Dublin regulation is partly integrated into that, but in addition, it also talks about the very controversial issue of solidarity, on which a lot of member states cannot agree, and it introduces a new governance structure to enable the EU to better respond to crises. The screening regulation is new, and it would add it adds a process whereby people upon entry would be screened, which meaning health check, fingerprinting, and then running them through the databases of the EU, and then they would be transferred into either an asylum procedure, a return procedure, or a border procedure. This border procedure, and this brings me to the second point, is arranged in the amended Asylum Procedures Regulation, which now introduces a new border procedure and expands the existing one. And then you also have an amended Eurodac regulation to integrate all of these changes. What remains the same, not compared to the 2013 proposals, but compared to the reforms that were announced in 2016, is the Reception Conditions Directive, which has been changed, the Qualifications Regulation, which is also, I mean, it turned from a directive into a regulation, making it much more binding for member states. The EU Agency for Asylum, which also hasn't been amended, the Union Resettlement and Humanitarian Admission Framework, and the Return Directive. The Return Directive was actually changed in 2018, and that version, they would still want to continue with that. Now, they had high hopes for the Pact. This is on the impact. They had high hopes for the Pact, but it seems they wanted to get an agreement under the German presidency already on some sort of roadmap, agreeing on the key issues, which is like the screening and border procedure, the solidarity mechanism, and cooperation with third countries. And the traditional contradictions emerged again during the discussions, meaning that Austria, the Visegrad countries, do not agree with mandatory solidarity, and they have serious doubts about a system of return sponsorship, which is proposed as part of the Asylum and Migration Management Regulation. And then the southern countries who want a more mandatory system for relocation because they fear they will end up establishing large centers where people will be locked up indefinitely without any access to solutions if all EU member states don't carry their responsibility. I will just talk about some of the key issues we've identified and then talk about the timeline for the proposals. So in the new screening proposals, everybody would enter and then have, you know, like I said, health checks, registration, fingerprinting, etc. And this would take 5 days, and in times of crisis, it would take 10 days. In this screening procedure, there is very little judicial review. There's very little clarity on which rights people have access to. The Commission has at times referred to it as comparable to an airport procedure. And for us, it means that children would be detained or at least contained upon arrival for at least 5 days. The screening procedure also puts a lot of emphasis on the role of the border guard, because you enter the screening procedure and then a border guard decides, based on the information he is given, whether you would be returned, whether you could enter a regular asylum procedure, or whether you go into the border procedure, which again entails detention. And this border procedure you can enter if your asylum claim was abusive, if you could present a security risk, or if you come from a country that has less than 20% recognition rate, which is the case for various nationalities arriving to Europe. So these are quite important life-altering decisions, and which also have a big impact on children. So we just wanted to highlight that this new pre-screening procedure has a lot of uncertainties about what happens to children. In the proposal, it says that people will not be authorized to enter the territory. so they don't call it detention, but I mean, it does mean de facto either detention or containment or controlled centers. In the new border procedure, which is part of the new asylum procedures regulation, unaccompanied children and children below the age of 12 would be exempt. We find this distinction quite arbitrary. How do you identify someone below the age of 12? Would this introduce some sort of new age assessment? It also kind of hollows out the definition of a child according to the UN Convention on the Rights of the Child. So we find this very problematic. We feel that all children should be exempt from the border procedure. And another thing that we found concerning is that it's still, the proposals are still vague on mandatory relocation. So what is good is that they want to give preferences to the relocation of unaccompanied children, but the proposal is still quite vague, and a lot will depend on the commitment of EU member states, which we can see in this ad hoc proposal that Commissioner Johansson has now implemented in Greece. There is some commitment, but it is very unpredictable. And I mean, the purpose of the Pact is to make this a more predictable system. There are also some positive changes. The Commission seems really keen to ensure that there's more monitoring at borders. So there will be monitoring as part of the screening regulation. EASO should also get a bigger role in monitoring. The Schengen system also provides some roles for monitoring, and Frontex also, we can see that there's a push on Frontex right now to increase its monitoring and accountability systems. So this is a good first step. For children, we also see that the guardian plays a bigger role, and this is mentioned both in the communication and in the legal proposals. The definition of a guardian is more fleshed out. The role of the guardian is clearer. They have access to more documents. They have more involvement also, for instance, in the best interest procedure in the case of transfers. So these are good changes. Overall, the Commission seems to pay more attention to operationalizing the best interests of the child. But still, I mean, there's a lot of work to be done in that area, but at least the intention is there. And then an important one is family reunification. They seem to want to reduce the heavy evidence requirements related to for family reunification. For instance, now some countries ask for DNA testing and other things which are really difficult to obtain, especially within very strict deadlines, which means a lot of children are left out, you know, especially when we talk about Greece and Germany. This is a real issue. So the Commission says that we shouldn't have like these heavy restrictive requirements like DNA testing if there's other coherent evidence available. So this would in effect make a big difference for children. So these are kind of, this is an initial overview, but Rebecca and Federica will go into more detail about children in the new Migration and Asylum Pact.
Thank you, Karen. And so this was to, as Karen said, this was to give you a little bit of a general information of what's coming up. And it was important for you to know that indeed this is the beginning of a process and not the end. So that's why this webinar, we want to try to understand what are the advocacy opportunities that are coming up, and on
I forgot to talk about the timeline, Federica. Is it okay if I just briefly mention the timeline?
Sure,
I'm really sorry.
Yeah, actually, it's a very important thing.
Very important. So just one thing to add. Like I said, this is the beginning of a process. So what they're doing now is in the European Parliament, they're starting to appoint rapporteurs. The different groups in the European Parliament are starting to appoint rapporteurs. Some of them have already been appointed. And then they will start, both the Council, the European Council, and the Parliament will start negotiating their positions. So we are expecting, I mean, we're expecting them to start developing their reports in the Parliament as of January. The EPP, which is an important party, has so far not appointed any rapporteurs. So we are waiting for that, and I think they will start working on it in January, which means the earliest we can expect reports is February. Then they will be brought in front of the Libe committee for a vote, and then they will be brought in front of the plenary for a vote. And at the same time, the council will try to establish their position on the proposals. And after they've both agreed on their positions, they will start going into trilogues, meaning the commission, the council, and the parliament will negotiate try to find an agreement on these proposals together. So according to my opinion, and also judging by the previous reforms, the earliest we could see some of these proposals approved is by the end of 2021. And that is a very optimistic scenario.
Yes. Great. Thank you, Karen. So indeed, this is the timeline that we have to keep in mind for our for each organization's advocacy, if you want to do some. Paola, can you show again the agenda, please? We are going to address now a little bit more in detail some key general matters related to the pre-screening. Can you go to the agenda slide? And then after this, we're going into more details of some legal guarantees and safeguards, for example, guardianship and legal assistance. We're going to, and general safeguards in general, we're going to then discuss some of the transnational procedures. We're going to discuss the return sponsorship and the other residency schemes. And then we're going to go through some main external matters. And Rebecca O'Donnell from Child Circle, Rosemary from PICUM, and Karen from Save the Children will address some of the following points. But I will start with some points on procedures at borders. And maybe the first thing that I will say is that Commissioner Johansson, every time she presented the Pact, when addressing the border procedures, which are indeed a big novelty in this Pact, justified these procedures by saying that it is important to have procedures borders because 2/3 of the asylum claims lodged in the EU are rejected. And therefore we need to be able to identify at borders who are asylum seekers that have reasonable ground to apply for asylum and those that don't have this. So the first thing maybe to say about this is that we had a look at the claim, and to us it seems that this reasoning is misleading. First of all, if we think about the data that Commissioner Johansson uses, she seems to refer to the EASO reports, annual reports, which say that actually 60% of the application end up with a negative result, but this only at first instance. Because when we look at what happens at second instance, so after an appeal is lodged, in 2019, around 20% of appeals ended in a positive decision, and in 2018, around 25% of the appeals ended in a positive decision. Therefore, if we make a little bit of calculations, we can see that there is a rate of 60 to 65% of positive asylum decisions within a year in the European Union, in the last couple of years. So the 2/3 claim, that 2/3 claim ends up in a negative decision, seems to be really misleading. And of course, we need to take into account different things. For example, that not all the appeals are of applications that have been lodged the same year. We have to take into account the backlog, but we also have to take into account the fact that there have been some stricter migration approaches in the last years, and we have seen less positive outcome for asylum applications in several states. But in addition, we also have to take into account that there are other protection schemes in place. There are countries that provide humanitarian visas, and therefore, if we start thinking about all of this, things start to be seen under a different light, and maybe we should try to use these arguments as well when it comes to border procedures. Do we really need them? I don't know. I mean, the data brought by the commissioner seems to be misleading, therefore maybe we should think about data again. But if we go into the details of the border procedures and what this means to children, Karen already mentioned a couple of very important things. First of all, it's true that the commissioner always says border procedures will not be applicable to accompanied children and children that are traveling with families that are below the age of 12. So the first problematic matter is this one, and Karen already mentioned it. Why are we distinguishing between children that are above or below the age of 12? This poses certain practical issues, for example, related to age assessment. But it also goes against the UN Convention on the Rights of the Child, the Fundamental Rights Charter of the European Union, and all legal instruments constituting the asylum acquis, which state that a child is a person below the age of 18. So making this distinction is really complicated from a practical perspective, but also in principle is a very, very dangerous precedent to make. There is also the problem that no children is excluded from the pre-screening procedure. So the screening regulation proposal states that screening should be conducted at or in proximity to the external border before the persons concerned are authorized to enter the territory, and that the member states should apply measures pursuant to national law to prevent the persons concerned from entering the territory during the screening. So this means that all children could be detained at borders for up to 10 days within this pre-screening procedure. And then if they are over 12 and traveling with their families, they could be detained up to 10 months at borders through the borders procedures. So both pre-screening and border procedures could lead to the prolonged detention of children. This is very problematic because until now, immigration detention of children was only a measure of very last resort. Of course, for children's rights organization detention, we always advocate that detention is never been in the best interest of the child and should never be for children. But so far in the asylum acquis, detention was always a measure of last resort. For the first time, this becomes the rule. Every child, in the worst case scenario, aged being older than 11 and traveling with family could be detained up to 10 months, and every child could be detained up to 10 days at borders. We know from different projects and from different organizations among you as well, that there is a great risk of prolonged detention of children in large centers. This is always traumatizing and is never in the best interest of the child. So if children remain for several days in the pre-screening procedures, which seems to be the case for all children now, to ensure that all safeguards are in place, it is essential that child protection authorities, civil society organizations, but also anti-trafficking experts, doctors, lawyers, translators are given access and properly resourced. So this is the basic. At least civil society, doctors, lawyers, translators needs to have access to the pre-screening facilities to be able that the basic safeguards are in place if we really want to continue with these pre-screening procedures. But the question is, can this work? Because is there such an ambition? What kind of ambition exists in relation to what can happen at borders and in 10 days as well? This is a very short time frame for a potentially very large group of children, and a step that is quite complicated to carry out. So if we think about where something similar was already applied, for example, in Greece and Greek islands, we already seen that this approach cannot work, doesn't work, didn't work there. In that case, children didn't have access to information provided in a thorough and appropriate manner. They didn't have access to all the support that was needed. The vulnerable cases were the ones that were most concerning. So it is very complicated for us to imagine how pre-screening procedures could work. especially if a needs assessment should be carried out at borders. How will this happen? Needs assessment is a very complicated process that can require not days, but months, especially in the cases of children that have gone through trauma, that have been trafficked, that have been abused, etc. So if we consider all of this, and we consider the fact that during the first days, weeks, and months of a child, the decisions taken for the child are extremely important and have an essential impact on the whole, not only on the whole application for protection of the child, but also on the integration opportunities of the child in Europe. We really have our doubts that a pre-screening would make sense. What in our opinion is realistic and should and could work is that if we have to operationalize pre-screening, this should be a system of referral. So at borders, what can happen is that a child is referred to appropriate services and support within the normal system. This is the only way to make sure that children don't get stuck in cage-like prison, in cage-like facilities at borders, that needs and best interest assessment are properly carried out, and that children have actually access to guardianship and legal assistance, and Rebecca will say more about this. So all in all, our main message here is pre-screening could work only if conceived for referral, and that member states should continue to invest in solid, normal reception and asylum systems. That it is important to invest the resources to address the gaps and the weaknesses of the normal, let's say, reception system, instead of spending resources in new facilities, in new processes, to try to guarantee a pre-screening that fully respects children's rights and safeguards, which, as said, in our opinion, it's very difficult that will happen. So these are our main messages on pre-screenings and border procedures. And maybe Rebecca can tell us a bit more about the general safeguards in the Pact.
Yes, indeed. Is the audio okay? I hope. Good. It's great to be here with everybody, and we did hope just to open up some issues on general safeguards. I mean, we all welcome the fact that there is a section in the Pact talking about children, because of course in the last Pact, notoriously, children were just a footnote. They were just in a footnote, a small reference. So it is a great improvement that Section 2.4 of the Pact has a whole focus on children, and not only on accompanied children, but children within families. So that's great. But what does it say? I mean, it recognizes that the best interests of the child must be really a primary consideration. And I'm going to come back to that in a moment, and in particular when we think about the transnational procedures that children might be subject to under the Pact. I'm going to just start with a few words on other procedural safeguards that are vital, and that's guardians and lawyers. Now, we're really glad to see the support for the European Guardianship Network and the recognition for unaccompanied children that representatives should be appointed more quickly, and that those representatives be given sufficient resources. Of course, the EU has done considerable work on guardianship over the last years, including the Fundamental Rights Agency, important guidance in the area. So we're happy that the Commission seems willing to build on this, and of course we support that. Importantly, the Pact also recognises that children should be offered legal assistance. And just to emphasise, it says legal assistance throughout the status determination procedures. And we believe that legal assistance is vital, and the EU must really do more than simply say that legal assistance is important. This is, of course, particularly because the Pact proposes very complex procedures. So if we think about unaccompanied children, of course, we're saying they should have both guardians and legal advisors. But unfortunately, some of the terms used at EU level generate some confusion. The EU proposals often talk about representatives, and they mean guardians when they say that. They don't mean, some people might take that to mean lawyers, legal representation. So we mustn't be confused by that. We must really pay attention to the fact that the two are both necessary. Guardians play a crucial role in supporting and assisting children, in ensuring their best interests are primary consideration. And often they play an important role in helping the child access legal assistance. But lawyers are needed because they bring specialized legal knowledge. They can advise on the child's claims in light of all the different procedures that might exist. They need to act in line with the stated wishes of the child. So a lawyer takes instructions from the child and acts on their behalf. And having a lawyer means that children can access procedures effectively. And of course, that's not only unaccompanied children. Children within families also need that kind of representation. So we believe this reform should have taken the opportunity to really make sure those procedural safeguards, guardians and lawyers were introduced for children in a much more consistent way across procedures. So that, for example, a child, no matter what their status is, no matter whether they're in a trafficking procedure, in an international protection procedure, in a return procedure, that they have access consistently to the same effective safeguards. So that's our essential recommendation on these safeguards. And we think everyone should pay attention to it. They should argue for EU law that sees that all unaccompanied children and children within families, no matter what their situation is, get legal assistance in all procedures and at all stages. So whether that's at the border, when they're seeking international protection, whether they're trafficked, or prior to a decision on return. And obviously this is all the more important as a safeguard when the procedures are getting complex and are getting severe in their consequences. Think, for example, at the border, just as Federica just mentioned, if a child is age disputed, they won't be referred away unless they go through a proper age dispute at the border, and for that they'll need access to lawyers. In the same way, we hear a lot about monitoring, and that the EU that national mechanisms should be in place to ensure that border procedures are properly monitored. I know the Fundamental Rights Agency will play a role in suggesting what those mechanisms should look like. And one of our key asks would be to make sure that what is also monitored at the border is the availability of guardians and legal lawyers for children quite specifically. And of course, it shouldn't just be a question that this is important for children. Having lawyers and good guardianship in place is important also for the state, because it's these kinds of assistance for unaccompanied children that can make sure that they get into the right procedures, that the right elements are put forward in a claim. So at a moment when the Pact says, let's have procedures that are more streamlined, then they should really be making sure these procedures, these safeguards are in place. So that's one element of key procedural safeguards. I'm going to come back to the issue of best interests procedures generally. And as Karen said, you know, we can see that more attention is being paid to this. You know, if we looked back 10 years ago, best interests might have really been only featuring in a recital of a directive. And then in the last directives, it moved into the directives articles. And then we see the Commission beginning to spell out, or rather EU law beginning to spell out what best interests should mean, you know, what you need to take into account. And now the Pact gets to a stage where it's saying, and we need mechanisms, we need a best interest determination mechanism. So EU law is definitely evolving, and that is very, very welcome. But is it evolving quickly enough? Again, particularly in this very restrictive setting. Let's look at transnational procedures in particular, because they've become all the more important under this new architecture that is proposed. By transnational procedures, I mean any situation where a child might be transferred from one EU country to another. That's long happened under Dublin, when children might be transferred for family reunification cases. It's also obviously happened a lot recently in the relocation efforts from Greece. We have seen also in Dublin that transnational or transfers might happen the other way around, that a child may have entered into a country, lodged an application there, moved on, and then in the new country, country B, let's call it, they have to decide whether or not to transfer a child back to the country of first application. Many of you on the call, of course, are very familiar with those situations and the difficulties that organizations face because the procedures are often very vague. And now, and Pekin will talk about this in a moment, now another new possible transnational procedure is being introduced, and that's the possibility for return transfers. That really is a very, very vague provision, and let's wait and hear what Pekin has to say. But again, it's very welcome that the Commission says we need a best interest determination before any transfer takes place. And as Karen said, they've also, the proposals also suggest that guardians should be closely involved in these procedures. Again, this is progress, but is it enough progress? Because again, it's important that best interest procedures are formal and robust, and that they can be appealed if necessary. There's still the risk that if we don't have enough formality in the procedure, it's really a risk that is borne by a child. So in our view, legal assistance should also be available to a child before this critical decision is taken that they may be transferred to another country. Now, of course, in some cases, the transfer procedure is precisely there to try and ensure the best interest is met, that the child is reunited with their family, or that they're moved away from overcrowded camps. We're not suggesting that that process should be choked and made too cumbersome. But what we are saying is that, in fact, having good legal advice to the child and the child's guardian might precisely make those procedures smoother and more sustainable and avoid unintentional problems. And what we are also saying is that in some situations, the transfer really may not be good for the child. And again, the lawyer needs to be there to help shine a light on these complex procedures. And they should be carefully in place. So that, for example, one difficulty with the current procedure is that the Commission has put forward the idea that if a child has entered country A, filed for international protection there, and gone to country B, that country B should be able to transfer the child back to country A unless it's not in their best interests. Now, that whole idea that there's an assumption that they should be transferred unless it's not in their best interest totally undercuts the notion that you actually have to look at what's happening in the individual case. I mean, it's clear that it may be dangerous, it may be risky for a child to be transferred back, and that in fact has been recognized by the court, the European Court of Justice, in its jurisprudence. So the suggestion that is made primarily, I believe, for migration management purposes, for deterrence purposes, you know, to set it up that children, if you move, you're going to be transferred back, so don't do it. And I understand that, but better it is better to deter secondary movement by giving children information and by giving them the support in the first country, and not by subjecting them to risk. So these are things we need to think about carefully. And the main point, I think, is this, that for transnational procedures, great if the principles are set out, great if the principles are clear and consistent and don't change in one situation, like that last one we just talked about. And we all need to push for procedures that are child-centered and that do support the child and that do engage the child. So much as with Dublin regulation in the past, you had general rules and then you had an implementing regulation to get into more of the detail. We must push for more detailed rules and rules that really help for cross-border cooperation between actors, because only the EU can put in place those kinds of rules. And we really don't want to see the EU saying again, member states should cooperate in best interests. No, set out a clear procedure by which they have. Don't leave any grey zones. So I'll leave it at that and over to Rosemary in Pecan to talk about returns.
Thank you, Rebecca. Yes, maybe to briefly introduce myself. My name is Rosemary van der Boogaert. I work for Pecan, and I am temporarily replacing our colleague Letitia van der Vennet, who usually leads our work on undocumented children and youth. And one of the last items that we wanted to address during this webinar before we move to the discussion, I'll try to keep it short as well, so we have some time for that, is the return sponsorship. This is a solidarity mechanism that the Commission is proposing in the Asylum and Migration Pact. And it is something that member states will be able to apply in case of so-called migratory pressure or crisis. This can be found more specifically in Article 55 of the Regulation on Asylum and Migration Management. And under this proposal, a country which is under migratory pressure would be able to receive support from another member state in order to return a person who, a third country national who received a return decision. And from our understanding, this will also include children either accompanied or unaccompanied. So for example, let's say Belgium is under migratory pressure, then for example, Hungary could provide support to deport a third country national that is issued a return decision in Belgium. And in that case, Hungary would provide counseling on return and integration. They would use its program and resources to support voluntary return. And they would lead the policy dialogue with third countries to facilitate readmission or organize a charter or scheduled flight. During this process, the child would remain in Belgium, and Belgium would, in that case, carry the responsibilities under the Return Directive. And if a person is not deported within 8 months, they would be transferred, in the case of my example, to Hungary. So in our opinion, this raises a few concerns. First of all, it's conceptually very concerning that there is a disproportionate focus in the Pact, it seems, on return. Just to give an example, the Commission's communication on the Pact mentions the word or the term return more than 100 times and the term rights only 14 times. So it's very paradoxical that solidarity, this being a solidarity mechanism, is expressed by deporting people. Furthermore, there are also some practical risks that we foresee. First of all, creating legal gaps in accountability. The fact that there is a so-called, or you could frame it as a threat, that if a person is not returned within 4 or 8 months, that this person would, in case of my example, be moved or transferred to Hungary. This could risk to act as a perverse incentive towards speeding up a return at all costs, which might where little consideration for human rights might be taken. And furthermore, it is unclear also in the Pact more generally how alternative residence permits are considered in this case. So in practical terms, this would mean that a child could be uprooted from, well, in case of my example, Belgium, where they might have gone to school, where they might have learned the language, being transferred to a country, for example, Hungary, where they have no ties. And furthermore, it is also unclear in what situation the children or a family might end up in this case in Hungary, whether they, for example, might be subject to detention, or if they end up in a legal limbo, what type of status they obtain, that's not clear to us. Therefore, we would recommend that children are not included in the return sponsorship scheme, as there are already more general concerns about the circumstances that they, also adults, might end up in after being transferred to the member state that is sponsoring their return. We think children should not be put in these uncertain circumstances. Furthermore, as Rebecca and Federica also mentioned, return should first of all only be carried out if this is in the best interest of the child, meaning that there should have been a best interest of the child assessment, and return should have been found to be in their best interest before this is even considered. And as part of this assessment, there should also be an assessment whether there are other legal pathways, other possibilities to obtain a right to reside, based on human rights law, for example. And overall, of course, the best interest of the child procedure should aim to find a durable solution for the child, whether that be return or otherwise. And related to this, this last point of the best interest of the child, we would also be in favor of appointing an EU relocation coordinator, who could support member states and all stakeholders involved to ensure a swift relocation of children and families. This is a position that has been discussed in the context of a new return coordinator, which was mentioned by the European Commission, but this has not yet been incorporated in the Pact as such. So that's something we would recommend. So maybe the last point, which I already briefly touched upon, is that there should be a clear moment in the return procedure where alternative pathways for children and families are considered, which may be found in national legislation and human rights law, as I mentioned. So maybe before we move on to the discussion, I believe Karen would briefly discuss the external matters. And then I think we have some half an hour or so to still discuss what has just been presented.
Right, and I already see some interesting questions on the right as well, and I think others can also respond to that, but I saw the question from Anne-Christine, if you combine the screening and the asylum procedures regulation with the crisis and force majeure regulation, you will see that in the force majeure, they include rules on extending the deadline of the 5 days, and also include rules on extending the deadline for the border procedure. So this is where you can find these exceptions. So let's look at the external dimension. So the external dimension, this has been a debate for quite a few years now. In 2016, the EU announced its partnership approach with third countries. We've seen an increased focus on Northern Africa. We've seen an increased focus on Niger, Turkey, the Balkans. So this approach is being consolidated also in the Migration Pact. So again, they want to put forward tailor-made partnerships, which include a wide range of policy tools. So they're not only talking about, well, they're talking about development, and this has been a debate in the parliament in the last week as well, because they really want to include migration conditionality in development funding. And this is now seeming to get a majority in the parliament as well, which is quite concerning. But also looking at other areas such as trade, defense, etc. So they want to build these privileged, they also want to build on privileged partnerships that some member states already have. Like, for instance, Spain has good relations, has been working together on migration with Mauritania and Morocco. So I'm guessing they will build on these partnerships towards the future. Like I said, also Northern Africa, specific focus on smuggling, Western Balkans, specific focus on border management, Turkey, but of course we know that there's a number of diplomatic sensitivities playing with Turkey right now. The NDICI, which is the EU's development funding instrument, has a 10% target to meet the EU's increased international engagement and specifically focusing on migration. So these partnerships look at capacity building to help partners with irregular migration, forced displacement and smuggling, strategic communication, and they always say, we want to have strategic communication on the legal channels that are available, but then also on the risks. So a lot will be also campaigns to discourage people from moving. And then strengthening capacity for border management, search and rescue. We see that there's some pressure on Tunisia to also conduct search and rescue operations and bring people back to Tunisia, and the strengthening of asylum and reception systems. Frontex will also, and this is already in the European Border and Coast Guard regulation, which was approved, which will also have a much broader mandate and be able to deploy and work together with a number of third countries. Previously, they could only work with third countries that were neighboring the EU, but now they can work with any kind of third countries. They're also looking at cooperation on readmission and reintegration. And one of the most specific things that is also in the Pact and included, if I'm not mistaken, in the Asylum and Migration Management Regulation is the visa suspension mechanism. So they will look at how well a country is cooperating on returns, and they will make a report about that based on a number of benchmarks, and if necessary they will take steps to restrict visas from those countries, which is kind of a punitive approach, and also again a shift, because the EU used to focus on more for more. Now it's also less for less. So yeah, they will sanction countries with free access to Schengen who sent a lot of abusive asylum applicants to the EU. And a thing that I do appreciate in this very controversial area is that there's much more of a focus on voluntary return than reintegration. So this is good. This is, depending on where you stand, but this is an improvement. So they want to have a voluntary return and reintegration strategy, and link it with a development initiative and national strategies. Of course, voluntary return often is just return in the absence while you're hanging forced return above people's heads. So there's kind of, you can ways to interpret voluntary return, but in any case, they want to have a more of a humane approach from that perspective, at least. But overall, more conditionality, more of a focus on readmission and kind of these deals that they're closing with a number of third countries, and return. And if you look at the council, the communication on the council side, you can see that return is really the main focus right now. That's it from my end on the external dimension.
Perfect. Thank you. Thank you all. Okay, so now we have some time for discussion. I hope that the presentations were informative. This was the goal of this meeting. It's mainly to give you some information about what are the issues that we find problematic, and it's not an exhaustive list, it's just the main ones for the moment that we consider priority. Now we have around 15 minutes, 20 minutes for a discussion. So of course you can take the floor, and I'll try to have a look now at the full list. But you can of course also share your questions in the chat box as you prefer. So the floor is yours. Is there anyone who has a question or wants to raise another point? This is also a possibility. Let's see. It's always intimidating to be the first one to ask something, of course. For the moment, I don't see anything. There is one big, yes, Karen had just shared the detailed answer to the question raised by Anne-Christine in the chat. So if you also wanted to know more about the legal basis for the longer detention of children as well at borders, have a look at the chat.
Hi there. I can't find the hand to raise, so I just talk speaking. If you I was looking, it's always the same. It disappears somewhere. I normally find it in the chat. It's Jacob. I'm also working for Save the Children for the German section. Hello, everybody. So I had some conversations with Karen already, but something I have not fully understood since I'm working on this since a few months, and I don't know so much the proposal from 2016. This idea of an extended family definition to the siblings, which we are welcoming a lot as far as I understood. Was that already in there in 2016? I'm asking that because I heard that Germany played a very bad role in the council in the first negotiations, which never came to a result. So for us as advocacy in Germany, that would be interesting to know if we have to be careful that Germany is not opposing that again. And a very simple question, does anybody have the consolidated form of the asylum procedure, since it has been proposed in 2016 and now amended, and I couldn't find that quickly, just the version how it would be now, if anybody could post that as a link, if you know what I mean.
Thank you, Jacob. I think this is something for either Rebecca or Karen, because this was in your points. I don't know if you want to.
Hi, Jacob. Siblings, and I talk to Jacob almost every day, so this is quite funny. So siblings and families in transit, these changes were already included in the 2016 proposals. The DNA stuff wasn't there. So I don't know which kind of role, actually, I'm not quite familiar. I don't really know which kind of role they played, but the negotiations were quite advanced, and I don't know if they would, I mean, they included it, so that means that they must think there's a possibility that there will be an agreement on it.
Yeah, I have to say that in my understanding, this also is not controversial. I haven't heard about Germany playing a particular role in this, and Karen, correct me if I'm wrong, but when we were in Germany in January, I think we addressed this with the representative of the German government that gave us an overview of the presidency's goal. And I think I remember that he mentioned that in his opinion, the family reunification was not controversial in this, I think. There is a question from Ida Miranda. It's about preclusion of information. It seems like the Article 12 is the same, but looks like an increased focus on preclusion of information not submitted in first member states, even when it comes to information on family, etc. Is it correctly understood? Does this refer? I'm not sure if I understand what you say, what you mean when you say Article 12.
Which proposal are you referring to?
Yes, which is the proposal that you're referring to, yes.
Okay.
Rebecca, is this something you're familiar with? Maybe you're best placed to reply.
I'm not quite sure which proposal, apologies. So it includes like increased focus on information not submitted in first member state. Apologies, I'd have to dig into the proposal you mentioned. We'll wait if you come back to it. Yeah. I haven't seen, but just to Jakob, I actually also was looking for a consolidated version. It would be very helpful. I mean, one of the things that when you look at these proposals that came out together, you practically need some kind of an X-ray machine, you know, to find out what's going on. So yeah, Jakob, if you find that, please do share it. We can also check with the Commission, and of course, State Watch is usually most helpful with documents.
Yes. But what we can do is that we'll follow up to this meeting with as someone asked. We'll send the PDF of that we used of the presentation that we used, even if there are only limited information because not all of us use slides. But we can still share this, and we will share as I announced, the joint position that will be open for endorsements this week. And we can, if we find the consolidated version, share it in that occasion. But yes, I also haven't seen it, so I'm not sure if we're going to be able to. If anyone else has any question, please do take the floor as Jakob did, because indeed I also not sure how to raise the hand.
Hello.
Yes.
This is Eva from DCI Belgium. We would like to analyze the new Eurodac directive. And so my first question is the same as Jakob. Maybe one of you know of a consolidated version of it. And my second question is, do some of you are currently working on this and want to join forces and share information?
So I can reply from my end that I haven't seen a consolidated version, but in the past we've jointly did some advocacy about the use of coercion when fingerprinting children, which in the previous proposal of the Commission was allowed. And we achieved to obtain a vote in the Parliament, which would change amend the proposal by allowing the use of coercion only as a very last resort and in very specific circumstances. So I haven't managed to look into it yet in the new proposal, but I would have a look at this specifically because it was a very controversial thing within the Council, and one of the issues that where it was not possible to find an agreement according to what we managed to know at the time. So it is important to understand what kind of safeguards are included in fingerprinting of children in the new proposal, because it's definitely something that at the time was discussed and was not a given.
If I may add, Federica, I also think the Eurodac provision is a good way to start a discussion about the rights of people in the screening procedure, because Eurodac would apply in the screening procedure because that's where people are fingerprinted. And we've always argued that children should have access to a guardian there when they're being fingerprinted, or some sort of representative. So this would give us a good entry point in talking about that. And to add to what Federica said, what they're doing in Eurodac is lower the age of fingerprinting a child from 14 to 6 years old, which is something not everybody, as Save the Children, we've not advocated against this because it's good in a way that children are registered in case they go missing, that they can retrieve them. But then there was this issue and they phrased it. I mean, there's been like various ways to phrase that specific provision in the Eurodac legislation. And it was on the table until the very end as one of the last outstanding issues. I mean, they rephrase it and saying no use of, we can do this, but then without using force, etc. Like there are different ways where they try to still say we can coerce or we can push people, but we're introducing a number of safeguards while we do it. So this is something I would pay attention to. But also, other than that specific article, we haven't been doing a lot of advocacy on it.
Yes, there is also a matter of how is this, how does this, because there is a whole action now around how different databases are connected and are used for different purposes. So it is important also to understand how the Eurodac information will be used in the framework of other databases, of the research launched in other databases. But one thing that I wanted to add is that from what I've understood, Eurodac will be one of the first proposals to be under negotiation. So it will be one of the prioritized ones. So it's also a matter of time to start looking into it as soon as possible.
Maybe I could just add a couple of points building on what people have said. I mean, Jakob was saying he was concerned to keep an eye on where the Germans might revert to a more restrictive position. I mean, obviously, the point of this call is to share the information. I know a lot of us are in European NGOs and work towards mainly the EU policymakers, but many of us also have members in member states, and a lot of people on the call are also based nationally. And we'd really urge you, when you see the draft or the joint messages that we'll be sharing, to see where you think your country may be most supportive of a point or less supportive of a point, because really a lot of the advocacy has to take place in the conversations we have nationally with our authorities. And of course, the Parliament is going to play a massive role in this, in making any changes, because even where people in the Commission might kind of see the reason for some of the changes we might be thinking about, at this stage, those changes would really have to come from the Parliament or the Member States. So just encouraging everyone to, when they see the joint messages, to really think about their national positions.
Yes, this is a very good point, Rebecca, and maybe it links to something that was shared in the Pact, in the chat by Athena, about, for example, what is happening in Greece. Well, it's not exactly the same, but it's a national perspective that strengthens our concerns. So basically, she's saying that indeed she also thinks, if I understand correctly, she also thinks how pre-screening and border procedures could work in practice, after which that in Greece this is not actually the reality. But she also has a specific question about the European Network on Guardianship. She would like to know more about what we think about the stronger role for the Network of Guardianship. Maybe, Rebecca, you want to say something on this, I guess.
Yeah, I mean, just very generally, the fact that a network exists is terrifically important. It's obviously a new network and it needs to be built up. But I mean, this is where we have an EU with cross-border provisions with people moving across borders, with procedures that go across borders, and we need more and better networks. So having a network really focused on guardianship for children, I think, is very welcome. How it works, that's something that's evolving, and that's something we'll continue to look at closely to make sure that the EU remains committed to funding it. But of course, the Pact seems to suggest they will, so that is good news. So it's a very important question, and we need to keep an eye on how it develops.
May I, because there's a huge question on Greece. So Rebecca, sorry, just finished. So I just wanted to add something to it, but if you're finished,
I'm finished. Yeah, absolutely.
No, I saw your question about Samos and the best interest of the child, and I think you're making a very important point. Operationalizing this pact in practice, and even having only 5 days for identification and registration. I mean, from experience on the ground, we know that this will be quite impossible. And even now in the last 5 years, there were like special rules for vulnerable groups already in Greece, for like unaccompanied children who should have been transferred immediately out of the hotspots and to appropriate accommodation on the mainland. But because there was no one to assess their vulnerability, and because there was no adequate reception on the mainland, they remained stuck there. So when we are talking about this, we should keep making this point that this may to some look like a good procedure on paper, but in practice we've seen it hasn't worked. One point that we're also making in our advocacy messages is that we feel that all countries should also invest in adequate protection. I know this is only a small part of the problem, but it is part of the problem that there wasn't enough adequate reception spaces in Greece, and this is why a lot of the vulnerable groups were stuck on the islands as well. So we feel that through investments through the Asylum, Migration and Integration Fund, that this aspect of strengthening reception systems and creating a level playing field of reception systems across the board should really be emphasized in our conversations as well on Greece. And just keep highlighting the gaps that we've seen in this system from practice. Even asylum caseworkers, it takes us such a long time to make important decisions like these, and then we would do it in 5 days in a screening procedure, which seems very, well, I don't know. You're right, that's my point.
And maybe if I could just very quickly come back to the point on the network, perhaps the issue was raised also with the thought that they might have an operational role in some of these cases, but at the moment it's not anticipated that the network would be there to be involved in individual cases in any systematic way. The procedure should be in place, and the network is there to kind of build capacity and support for the system. And also maybe on individual issues, but it's not yet evolved into a kind of an operational case management system, and it may never do that. So I think that might have something to do with the context you raised the question in. And absolutely, Karen's point, agreed that we're saying don't be ambitious about what happens at the border. Refer away and have the reception capacity that can absorb that and deal with it properly. Jakob also raised the point about the reversal of the burden of proof, and that also goes to a point I was trying to make, but maybe didn't make clearly enough. We do see that as highly problematic, in the sense that why should it be, why should the burden of proof be reversed? Why should there not be a proper best interest procedure in that case? I remember that previously people said, oh, we best interest procedures are clunky or cumbersome. We just need working assumptions as to what's in the best interest of the child. But we don't want to see these assumptions here. We want to see the procedures improved so that they can be implemented quickly, effectively, and properly. No more assumptions. Every child's case may be different.
Yes. And maybe on this, one thing that I want to add is just about the unlikelihood that this will not be the case at the end, because this was already something that the Commission proposed to change with specific legislation still in 2014, I think. after the judgment in the European Court of Justice that actually said that that actually asked the legislation to reverse the burden of proof. And whilst in the parliament did vote in support of the reversal of the burden of proof of the child best interest, the council was absolutely against, and it was never possible to move from that standstill point. And therefore the proposal was simply abandoned, and they moved towards proposing what is now in the Pact a few years later. So I honestly, because of the previous experience, I honestly don't see how something different could pass in the council.
Maybe I could just pick up on Athena's point in the comments that it's very important to enhance the screening procedures and the vulnerability identification process. And we totally agree. I mean, we miss this, a lot of this call has been where we're saying the border procedures proposed are very difficult and restricted. But obviously we also see the borders as a moment, as an opportunity to identify and help children. So having the right people there to identify and refer away, just as long as we don't try the old hotspot approach, which was meant to be crowd a lot of resources into a border and identify vulnerabilities, and it didn't work. So let's keep it simple. Have the right people there, but also in principle, move to refer away as quickly as possible. All children unaccompanied and children within families.
Indeed. Is there anything else? I don't see any new message in the chat. Any final comment from the audience, from the participants?
One more question if we have time. Sorry, just to clarify that in Germany, apparently there is an opposition against the extension of the sibling family thing. We had a hearing in the parliament where the head of our asylum agency, invited by the Conservative Party, was very much against this and saying Germany should go against it because Germany will be one of the countries getting a lot of more applicants, and we have already so many. Just to warn you, I think this is something we will in Germany point out. And then something totally else. Because we have relocated now 1,500 people who were already refugees, who got a refugee status in Greece, as you know, from the islands. And that's something I'm not very good in, but I think so far it needed 5 years until you could move on within the union. And now it's 3, isn't it? And which regulation is stating that? And do you see any room for pushing that even further? Because I think this is also one of the big problems. Nobody wants to get asylum in Bulgaria or Greece because you still end up in the streets or on an island without any perspective.
I think the relocation point was mainly with you, Rebecca. Do you want to give a feedback on this?
Just to address what Jakob just said, I mean, I think if in countries which have recognized asylum seekers as refugees, if refugees obviously have a quicker way to move on, that would resolve a lot of the issues around solidarity mechanisms. But I don't think there's any intention to improve that significantly for the moment. But it is absolutely a great advocacy point, you know, for EU level for the future. Yeah. And on family reunification, obviously the numbers for Germany would start adding up, so can understand the wariness of it. But on the other hand, it's a difficult argument to make. It's a pretty inhumane argument to make in ways when we see the family separation cause. But I know you know that.
I saw Jacob's question, and actually I also don't know from in which regulation this is arranged that you can move to another country after so many years. Qualifications, I don't know. Rebecca?
Long-term residents.
Long-term residents.
Yeah, is part of it. But I mean, ECRE for years has been calling for that kind of approach, whereby if someone is recognised as a refugee, then let them move elsewhere in the EU, have positive mutual recognition of positive status. But it's not yet fully developed, as far as I know. We look into it more closely.
Yeah. Great. So thank you very much. Our time is up. Thank you very much to everyone, to, well, my colleagues, co-organizers, Karen, Rebecca, and Rosemary for this. Thanks, Paola, for the support. And we'll follow up, as said, via email and with the joint position. And please get in touch in case you have anything that you want to discuss further. So till the next webinar on the 7th of December on relocation. Bye.